the future of antitrust enforcement. This is a very exciting, big topic for us. I'm Teddy Downey, Executive Editor here at the Capitol Forum. Today's guests are Michael Kades, Antitrust Partner at Nachawati Law Group, and former Deputy Assistant Attorney General for the Antitrust Division at the U.S. Department of Justice, and Adam Gitlin, Chief of the Antitrust and Nonprofit Enforcement Section at the Office of the Attorney General for the District of Columbia. We're going to be talking about state-level enforcers, how they're shaping the next phase of antitrust policy, and what their growing influence means for markets, consumers, and competition nationwide. Michael, Adam, thank you so much for doing this today.
Thank you for having me.
And really, just, oh, go ahead. Well, before we get started, just want to really quickly go over some stuff. To submit questions, type them in the questions pane of the control panel. We'll collect questions. We'll address them at the end. With that, why don't we start, Michael and Adam? Clearly, we're going through an interesting time of federal antitrust enforcement. Would love to get your take on what's going on right now at the DOJ, the FTC, and how you see states sort of fitting in there in terms of sort of filling in the gaps or what have you.
Sure, I can start. Let me just say thanks again, Teddy, Capitol Forum, for having us on. The usual disclaimers apply. I speak only for myself, not for the DC Attorney General's office or the Attorney General, and especially not today because I'm looking forward to some freewheeling conversation where I'll do my best, subject to those limitations, to give my views. I think there's a lot going on in federal antitrust enforcement, and some of it is going to be stuff that the states are going to be joining in on. Some places where you might see a little less action by the states, and some places where you might see more. One of the things that I think we are all recognizing is that there's been a fair amount of, pent up capital for mergers and acquisitions that is now finally starting to get deployed. And every time there's an M&A wave, federal and state enforcers have to figure out how to deal with it. And that may mean that they don't get the same, you may see a dramatic increase in M&A activity, but you don't really quite see the same dramatic increase in the staffing for the merger enforcers. And so they've got to figure out how do we prioritize? Where do we focus our efforts? And where does it make sense for, states to do more focusing and the federal folks to take the lead in others?
Yeah, no, I think Adam has totally hit the nail on the head. Look, interest rates have come down, so that's going to spur merger activity. The new administration has made it clear they have a different view on settlement than the prior administration that I was part of had. That's going to spur merger activity. But at the same time, both agencies continue to have very existing active dockets. Department of Justice, even getting through the Google remedy phase, they still have Apple, they still have Visa, they have the AgriStats case, they have a number of cases, as does the FTC. Then you have, who knows how appropriations are going to work. And then finally, both agencies have seen a significant reduction. People have left. So they have a lot of things they're trying to balance. And, I think the issue is that there is a lot of room for state enforcement in this environment.
And I will say, let me add on the state enforcement point that a lot of the states have increased their staffing over the last few years. They're increasing their staffing both in terms of the number of people working in state antitrust enforcement. Yes, there are still states that have one or two antitrust enforcement lawyers and for a variety of reasons, but there are a number that have way more than that. And not only that, but a lot of the time now, to Michael's point, they're pulling from the ranks of federal enforcers in some instances. They're bringing on folks who, like me, kind of got a lot of their training in the DOJ Antitrust Division or at the FTC, and that improves not only their capacity but also improves cooperation with with federal agencies, because there's a bit of familiarity there.
And one thing that I think we've seen really recently is the states also, holding the DOJ and the FTC accountable in some respects. You've got the states asking for discovery in this HPE situation around the Tunney Act stuff. Historically, states have made it, more difficult for the federal agencies to settle if there's a merger or a investigation or a conduct investigation or lawsuit that they're party to. How do you see that accountability going forward? Is that the right way to think about what another thing that the states are going to be doing?
So from an outsider's view, it does seem to me, without commenting on what the issue is in HP Juniper, it is no doubt that there are a lot of people who are questioning the integrity of the federal enforcers, and particularly the Antitrust Division. So if I were there, from my perspective, in any ongoing settlement or litigation that I was considering, I would really want the state AGs on board as a way to sort of protect against that kind of suspicion or criticism, which I think gives the state AGs a lot more authority and a lot more leverage in pursuing their goals, which hasn't always been true. I mean, a lot of times where you have federal and state together, there could be a tendency for the feds to basically take the position, we're going to settle, you do what you want, but we've committed all the resources. And I think maybe that's shifted just a bit, or maybe more than a bit.
So I can't add, because at this point, DC is involved in this Hewlett-Packard Juniper matter, so I'm not going to talk about that. But I'll say, just taking a step back, that the states, consistent with what Michael just said, the states will generally, if they see a merger they have concerns about, they're going to act. And the procedural posture might be different, right? If somebody else, maybe the Department of Justice, has been litigating the matter, and the states, have a concern about it, they will join in whatever fashion makes sense given the posture at the time. This is not, in that sense, new, right? An example that people often think about is the Sprint T-Mobile matter, where you had, this is back in 2019, where you had the Department of Justice in some states settled, and other states were not satisfied with the settlement and proceeded to litigate to try to block the merger. I think that's consistent with this idea that states are, one, not monolithic. They're going to make different decisions depending on the situation, and two, they're going to act based on whatever the posture is of the case and what they need to do to protect their residents.
I just want to stay on this for one more second, because I think it's really interesting. Right after the HPE deal closed, a lot of consultants were going to merging parties and saying, hey, look, all you have to do is hire Mike Davis, hire a bunch of MAGA lobbyists, get the White House to weigh in, and you'll get your deal through. But what you're saying, Michael and Adam, to some extent, but really what Michael's point is, actually, because you have states who can weigh in and expose any overt or even subtle corruption that taints these deals, that it's discouraging. It actually, not only it's discouraging that strategy and makes it really risky, and now you even to the point where now there's going to be, to some extent, an assumption of some kind of corruption when you've got a settlement on one of these matters. I don't want to put words in your mouth, but I think that is, to me, from a strategic sense, really different from where we were even a few weeks ago when everyone was celebrating this HPE deal getting done.
Right. I mean, again, at this point, no involvement in the HP Juniper matter, so I don't want to comment one way or the other what actually happened. But I think looking at the dynamics, the state, if you're a federal enforcer, you don't want a repeat of that public issue. So regardless of what's happening on a given settlement, you now have to say, wait a minute, we have to make sure that we need the states on board, because otherwise we're going to be spending all of our time dealing with criticism, so that the states now are in a position to sort of legitimize the process, because if you have a settlement and it's the feds and the states are all on board, then it's far less likely that people are going to think something untoward has happened. So I think that puts the states, one, it gives them a really important role in enforcement in the short term for legitimacy, but also increases their ability to direct the outcome of merger challenges based on their independent judgment.
Yeah, the only thing I'll add is, there's a bit of paradox here, because I think oftentimes there's been a thought in the defense bar that when it comes to antitrust, it's true that states are increasing their antitrust chops, but that with a state AG, there's always a bit of room to consider non-antitrust factors when you're doing merger review, right? That is that, if you can, that it may be a little bit more like things sometimes proceed, for example, in front of the FCC or an agency that might have a broader ambit to think about what's in the public interest. And so you have these interactions where they're actually focusing on, well, what can we do for a state AG that might not necessarily quite address the competition problem, but gets us over the hump? And so there's a bit of paradox here, because we may be entering an environment where the states are being extra mindful in some instances that we are all, as government antitrust enforcers, responsible for really trying to tie these reviews and these cases to the merits. And if that means folks want to try to find other ways to get deals done, that's a new reality we're going to have to live with. But it's kind of on all of us to make sure that we stay faithful to the statutes we're actually enforcing.
So I just want to say, I think Adam makes an excellent point there, and I guess maybe to take as a friendly amendment, I'm focusing on, I think the states have more room to operate in this, and it depends on how they choose to use it.
Yeah, I mean, super fascinating. We'll continue to watch, the state involvement on things like this going forward. Not everything is easy for states. Obviously, there is a bit of a push and pull with the federal government restricting resources to specific states, mostly blue states. State budgets aren't in the greatest shape in the world. Adam, you mentioned there have been hires in the antitrust space at state AGs, but what is the outlook going forward for funding for state AGs when it comes to antitrust enforcement? And what are other challenges that the states face? Obviously, they can't step in and sue every deal. They're going to have to manage their resources, but would love to get your take, and Michael, your thoughts as well on what the challenges are and how they could deal with them.
So I think there are two resource issues that the states are always going to face. One is that antitrust is a labor-intensive practice. There are very few cases that don't require multiple attorneys working on them in order to litigate them effectively and investigate them effectively as well. And not only that, but even in the investigative phase, there's often a need for economic analysis. Now, it's true that you've got more states than ever with in-house economists. Massachusetts, California, Texas, New York, Pennsylvania. There's probably a few I'm omitting, but that generally speaking, they still have one or not much more than one economist, and so they've got to make do with either what they've got or hiring outside economists, which is way more expensive. And so those, unless there is a, and there are folks who've made efforts at even the federal level. I think actually, Michael, was one of the last things the FTC and DOJ did sort of together, perhaps at the towards the end of the Biden administration, the beginning of the new one, and that got carried forth, was a request for Congress to try and find a way to make antitrust litigation more expensive. Well, if the federal agencies were seeking it, you can imagine that holds doubly true for the states. So that is always going to be an issue for us. I think for the states, there are a couple of ways we've been trying to address those issues, and we're going to probably see more of that, right? There are ways where the states can work together. We can pool resources. That allows also some states which might have, for whatever reason, smaller budgets for actually paying experts, but greater budgets in terms of labor, to be able to help out and work with other states that might have more money for experts and maybe proportionately less labor. There's also ways that states can take on greater roles in particular litigations, even if they're joined by the feds, right? There was a couple of recent cases brought by coalitions of states in the wake of the NCAA versus Alston case, one against the transfer rule, the other against the name, image, and likeness rule. And in one of those cases, DOJ joined the states as a co-plaintiff. It still didn't actually, lead the litigation, but joined, and there are resource sharing agreements that I think are even increasing now among the states and the FTC and the DOJ. The other area to do a plug for Michael is in the use of outside counsel. I think there are a number of different ways we are seeing states partner with the private bar. Sometimes it's being done in a pay-as-you-go way, where the states look forward to trying to get attorney's fees at the end, as Washington State did in its challenge to the Kroger-Albertsons merger. There are other situations where, and DC probably does this a bit more than some other states, use outside counsel on a contingency basis, where it's kind of beneficial across the board. We can talk about it more if you'd like, but that enables us to leverage our resources as well.
Yeah, well, thank you, Adam. I do think the NCAA matter is, it doesn't get a lot of attention, but it does really reflect the way in which state enforcement is really an equal partner with federal enforcement. That was one of my matters, and the states moved first. We thought it was a great case, and we joined it. We didn't have to lead it because they'd done the work, and that it expanded enforcement resources for both the feds and the states. And I think Adam makes a great point that states can be creative in how they leverage their resources, right? And so the way I've been thinking about this a little bit is take a small healthcare merger, small in the sense geographically, in a relatively smaller rural state. The harm relative to that state is substantial. That state may not be in a position that they can hire 6, 7, 8, 9, 10 antitrust lawyers, as Adam points out, but the sort of fixed cost of antitrust litigation is substantial. You don't see many people trying an antitrust case with 2 attorneys. And so you have this issue that from a Fed perspective, it may be hard to justify the resource commitment because it's a localized harm. And the state is not in a position to sort of carry that much of an antitrust team. Hiring outside counsel, and there are a variety of ways, as Adam suggested, you can do contingency, attorney's fees. There are all sorts of ways you can do this. Can allow the state to really enforce more aggressively than it could otherwise. So I think it's a really important tool out there. It's been, you see it a lot. It's been used significantly in consumer protection cases, and some of it, DC has used it in addition to Washington in the antitrust context, as of some other states. And I think it's a real unexplored option for states to ramp up antitrust enforcement.
No, I think it's a very interesting trend to watch, especially if the states are trying to be more aggressive. One tool that I wanted to ask about, particularly Adam, are these new merger notification laws. That's been a trend across the country. How do you see that playing out? And in particular, maybe we could just at a high level think about what are the types of deals that are of concern to states, and how do they think about priorities when it's coming to mergers, and then maybe we could get into conduct after that. But yeah, it's merger notification laws and kind of how that fits in with state priorities on mergers.
Sure. So on the pre-merger notification laws, right? So there were already some states that had some form of pre-merger notification requirement. I think there are a couple of, like, maybe let's say 3 trends that are, or issues that are making things more interesing now, right? So the one that doesn't relate to what's actually happening in the States is the new HSR form allows for waiver by the companies that would allow the feds to share information with the states. Historically, the practice had been that the states would go to the companies and ask essentially for a waiver. But a lot of companies are giving out those waivers less now, which might relate or not to some of what we've already been discussing. And so it's interesting to see some of the other things that are happening, right? So one thing is you've got some states that are focusing on trying to pass pre-merger notification laws that focus on particular sectors, and really in healthcare is where this is biggest. A couple of years back, Minnesota enacted a pre-merger notification law where that covers transactions like mergers and transfers of ownership. And if I think the threshold is something like $80 million, and if you've got average annual revenue or $80 million or more, there's a 60-day pre-closing notification period. And I think that was driven by a non-reportable transaction, or one that for whatever reason Minnesota's AG's office wanted to be able to review before it actually occurred. There are other states that are doing similar things, and similarly, you've got this this ULC, the Uniform Law Commission, periodically puts out draft model legislation, and one of the most recent things they did was a model pre-merger notification law that is basically supposed to be set up that if a lot of states adopt it, the states that are most affected are going to receive pre-merger notification. Others may have access to this sort of common database in some way. And Colorado and Washington this year became the first 2 states to pass it. It's pending in a number of other state legislatures, including mine. And the thinking is there that also that way, those mergers that are of particular concern to a given state, they're going to be able to focus on it. They're going to be able to address it on the front end, and you won't just have also this sort of patchwork of states, tackling a particular transaction. You're actually going to have it be a little more focused. And I think there's an interest in that for the merging parties too, because the flip side of the benefit of let's say the flip side of the burden of pre-merger notification is an argument of repose. That is, if a state gets pre-merger notification because it's getting it through this new system or through some other law, the idea is now is your time to act. And states will make arguments about mergers that they maybe were notified about and didn't act on at the time because they may have had good reason not to act at the time. But it's a very fair argument that merging parties are going to make. Hey, you had your shot under this new regime. You decided not to act. That was your chance. We get to merge.
Michael, any thoughts on when it comes to mergers and state AGs and how they're what they might prioritize? I'll come up with a couple specific examples or themes, but anything that jumps out to you?
The first place we can look is just what Adam was talking about. Is a number of states have passed merger notification laws, but that are specifically limited, and generally it's limited specific to healthcare, or private equity. So that's a really clear signal that any state that does that is specifically concerned. I think the second place I think you should look is just look at the state and what's important to that state. I think, to the degree a state that has a significant presence in agriculture, you would expect that to be an issue. And so, that's how I would look at it. California, you would expect them to be really concerned about mergers in the tech space because they have a lot of tech that's a big industry for them. They may be very concerned about how a merger affects the labor side in that market. So I think also you need to expect them to be the same issues that concern the feds. It's clear the states are equally as interested in things like algorithmic pricing. So they may, to the degree that comes up, information sharing. Those would be the areas how I would sort of expect where states would go.
I want to stay on. Oh, go ahead, Adam.
Just one more on because I realized I didn't totally answer the question in terms of how these new regimes fit into how states are looking at merger enforcement. I think it's important to remember that partly because the states have such varying setups, they will often take advantage of their ability to kind of pave their own path and be really nimble about how they address whatever issues they might face in terms of trying to protect residents. It won't necessarily be in the hot areas we might be thinking of like healthcare or tech, right? The best recent example I can think of, or at least one of them, is New York AG's office went after this ski resort merger. This was Intermountain's acquisition to basically allegedly create a monopoly for season pass holders in the Syracuse, New York area. They used the New York's Donnelly Act, which I know from my days being in the plaintiff's bar lacks a Section 2 equivalent, right? So it doesn't actually have a monopolization section. And so they went at, but they did have a written agreement, which gave them, an ability to go after it under their sort of Section 1, Sherman Act Section 1 analog. They won affirmative summary judgment on liability, which allowed them to, and they did it with a per se allocation of market. So they didn't have to do this really expanded, economist paid heavy work. They used I think an in-house data analyst to submit a declaration and then give them, the quantitative information that they wanted. And in that sense, they won on liability. I think they recently had an evidentiary hearing on remedies where they used their in-house economists to testify, right? So they managed without any, elaborate new pre-merger notification scheme, and without even, and alleging essentially a monopolization, without having a monopolization statute, they protected their residents from what they considered to be an anti-competitive merger. And you're going to see that kind of inventiveness, I think, in the coming years from states, regardless of whether or not it's an industry where we have particular concerns.
I want to throw out a specific theme here. There are a couple of active mergers in the media space, a lot of consolidation. At the same time, there is a lot of concern about billionaires controlling communications platforms and media properties. Would that be a space where you could theoretically see a state say, diverge from where the FCC and the Trump administration are, potentially in terms of intervening in a merger or otherwise being more skeptical of merging parties' arguments around why they should be able to consolidate media properties? Adam might be limited in this, so maybe Michael, if you can start off and give your thoughts, that would be great.
So let me be the the two-handed lawyer on the one hand, on the other hand. On the one hand, media is the most obvious example where states have an example of disagreeing with the federal government and Sprint T-Mobile. Right, they did not agree with either the FCC's approach to that case nor the DOJ's, and they sued to block the merger. So I think it's obviously something that can happen, and I think it's an issue that really is not just a federal issue. I think it's going to be incredibly important to states, particularly when we think about the impact on local news. That's a big, I think, a clearly important issue. The other hand is it is very difficult for I think what T-Mobile Sprint shows is it's very difficult for states to come in and say, Judge, two federal agencies got this wrong, but we also only have, so I guess I'm a three-handed attorney now because we only have one example of that. And so I would be careful to say, because of the result in Sprint T-Mobile, states are going to stay away from that. But they obviously, where there's a state federal split, it does make it more challenging. So hopefully I've really muddied the waters there in that answer.
Adam, any thoughts? I'll have a follow-up for Michael, but if you, I don't know if you can weigh in high level.
I will weigh in, but less on sort of where the question started and more where the answer ended. So I think there is a general sense sometimes among state enforcers that there are instances where our state courts are going to give us not deference, but maybe a bit more credit than we might enjoy in federal court in certain kinds of actions. And one thing I think you might see more of in the coming years, that New York case I mentioned that was brought in, in New York State Court. If we're talking about mergers in Washington State, Judge King issued a much longer opinion in the Kroger-Albertsons challenge. Doesn't mean it was better, but the point is it was thorough, and it was based on consumer protection law than Judge Nelson did in federal court. And I think state law can be really powerful. There are remedies that exist that are not necessarily available to federal enforcers, and that maybe have even sort of more force in state court proceedings. So that is one way you might actually see more enforcement on both the merger and the conduct side.
I guess another way to think about this is you have a couple of distinct things that happened during T-Mobile Sprint. There wasn't as much of a question of the federal government. I think there was a willingness to still be deferential to the federal government's, trying to think of a way to phrase this, respect for the rule of law. And this administration, I think that's maybe a little bit more up in the air in terms of how states think about whether or not the FCC and certain agency actions are being done in good faith. And also you had that, to Adam's point, that was in DC, right? So, is the lesson there, hey, maybe we just shouldn't sue in DC, look at states, look at other jurisdictions, and then B, do you think that the just change in attitude and by the states, their view of what's going on in the government currently is materially different from what we had even in the first Trump administration, to cause people to be a little bit more aggressive, be a little bit more willing to step in and challenge the administration?
So I think T-Mobile Sprint. I mean, and Adam's point, I think it was in federal court. I think it was actually technically in the SDN, Southern District of New York. But the point still stands, and Adam's exactly right. There's this unexplored option of a state going into state court. Most states have their own antitrust laws, and there's nothing wrong. And in fact, the legislature, if it's passed the law, is fully expected, that the AG, Attorney General, will do that. And this isn't empirically based, but it makes sense that a state court judge may have a very much less interest in giving deference to the judgment of federal agencies, and also probably respects the state attorney general in ways that federal courts may or may not. So I think that this is so I think that's absolutely true. And I do think, Teddy, you're absolutely right that in the ether today, concerns about rule of law, the politicization of enforcement permeate far more than they did in the previously in any administration. But I do also think it's interesting that you bring up that point, because part of the reason the states, I think, went forward in T-Mobile was there, not to the same degree, but there was a concern that there were improper communications between the parties and senior justice officials. So I think it's a sign that if that's true, you would expect it to be even more true as a cause for generating state enforcement.
I'm not sure you can answer that, Adam, but should we just move on?
It's probably easier. I mean, I think the point about, I'll go back to this point about sort of states trying to have always this like a variety of arrows in their quiver. And that's part of what animates some of these proceedings happening also in state court. Look, DC has, two pretty significant antitrust cases right now proceeding in DC Superior Court. One about, algorithmic pricing in rental, multifamily rental housing. One against Amazon for provisions relating to most favored nations clauses and similar provisions, and those are making antitrust law in DC. There's DC doctrine on antitrust law now for for the first time in certainly in recent memory, and that can be helpful, and can provide alternative paths for doing different kinds of enforcement. And there are a lot of states that are trying to do these sort of homegrown different kinds of enforcement matters to try and protect their interests, and that's going to happen sort of no matter what big ticket thing may be happening also at the federal level. These are great. It's been a great year, for example, for like the Connecticut AG's office in terms of tackling bid rigging issues. They've got 2 cases in the last year that basically tackled situations where they had, I think these were both married couples, where they basically created 2 companies to essentially put together competing bids, but where they were essentially the same, it was really the same operation. And then, the winner would subcontract that to the loser. And this happened with an asphalt company, I think, in December 2024, and then more recently moving companies. But they and others are really trying to focus on not just the sort of nationwide high news getting activities where some of the kinds of concerns Michael's pointing out definitely have a role, but also where they're going to be, it's either them or no one is potentially going to act on some of these issues. And that's not going to slow down.
I want to circle back. We mentioned, we've mentioned algorithmic price fixing. I wanted to ask more broadly, and then maybe we could dig into that specifically, but are there sectors that states are really concerned about or focus on? We mentioned healthcare, we've mentioned tech. I think agriculture has come up a lot, particularly recently. Where should we expect states to really focus their attention when it comes to both merger enforcement and conduct?
So I don't know offhand whether or not that it's fair to say that there are particular sectors in which the use of AI is or algorithms is going to be especially the focus of states. I think actually, in that sense, government enforcers across the board are sort of figuring this out and are most there are two things that are happening, right? One, we're learning about how these different kinds of software work, right? But we're also learning about how they're being used. And so, you know, at least in the antitrust bar, like the well-known analogy that former FTC Commissioner Olhausen used about, you know, just replace the algorithm with a guy named Bob, and if that wouldn't be okay, then it's probably not okay for an algorithm to do it. You know, understandably, enforcers are focusing a lot of their ammunition on industries where either the algorithm is likely to have a great effect or where the conduct just seems really hard to justify. That is to say, you know, how the algorithm is being used, even whether or not it has a great effect, seems so obviously problematic that if we replaced algorithm with, you know, a messenger model, the way companies in some industries have at times used a third party to aggregate information. If it was problematic, the enforcers went after it. And here we're going to see a lot of the same. And I don't have, you know, bases, kind of like a priori to think that it's going to be in some industries over others. We're seeing it. I think we saw, yes, a lot of it in particular industries at first, but it's only expanding.
I would only add that I think states, even more than the feds, are really focused on things that have specific harm to their citizens, whether they be consumers, workers, business owners, you know, and so I think that drives a lot of state enforcement in ways, if we're trying to think about how it's different. It's not that the feds don't agree. It's not that the feds don't think about that. We absolutely did. I'm sure they still are. And it's not that states don't care about sort of doctrinal issues or practices. It's just, I think the balance of those issues is a little different based on where you sit as an enforcer. Sorry.
Maybe another way to think about this is, you know, we've seen at the Trump administration, you know, even as they are looking to wind back or take the foot off the gas of antitrust enforcement, particularly around mergers and allowing more settlements, they are still pretty seemingly gung-ho about a lot of these ongoing Section 2 investigations. You saw the FTC sue Ticketmaster recently, and I think a really underappreciated, pretty explosive lawsuit tying Ticketmaster to untoward conduct in the secondary ticketing market. You've seen DOJ continue with its United Health investigation, continue with its Ticketmaster enforcement. You know, these issues that are very consumer facing, and that might actually result in citizen blowback. Do the states think about pocketbook issues or sort of things that are top of mind to their citizens, and should we be looking at there? I mean, there's been a lot of focus on housing, for instance, and algorithmic pricing on housing, you know, rentals. We've done reporting on algorithms in food and groceries, and you know, there's a long laundry list of these algorithms popping up every day. Eggs, protein, you know, you name it, you can probably find someone coming up with an algorithm. There's even an algorithm in healthcare where in response to the health insurers having an algorithm push back on pricing by providers, the providers now have an algorithm to push back against the health insurer algorithm. I mean, so the war of the algorithms popping up every day, this seems to create a big potential opportunity for states to intervene, either state AGs, legislatures, and are these pocketbook issues relevant? And then secondly, let's say you're dealing with these, cockroach type problem. Is that one area maybe, Michael, where the states could really look to, outside counsel to help complement or supplement their own enforcement resources? And maybe Adam, if we could start with you and then go to Michael, that'd be great.
Sure. So I definitely, the phrase pocketbook issue gets used in the halls of my office, and I'm sure in the phrase in the halls of many other state AG's offices. It's always going to be a concern, both in terms of what we think our residents want, and also how we have some of the most palatable impact in some of our enforcement matters. So yes, we were very involved when in the case we brought with the FTC to block the Kroger-Albertsons merger, because both companies own, have significant number of supermarkets in the district, and we were worried about prices for groceries, among other things. So that I think we're working with the Department of Justice and the FTC on a number of matters, some in litigation, some not yet, but generally focusing on the bread and butter issues that ordinary people face. I think there's also a bit of a synergy when we sue for damages to residents, right? That is, our parents' patria authority is most often invoked to say, hey, you've overcharged consumers who are our residents, and what do consumers buy, and what is the connection there? It's the things they use their pocketbook to buy. That is, things that are sold directly to consumers, and whether that's groceries or concert tickets, it doesn't really. It's not as if we start necessarily by saying, hey, we want to go after this particular industry. We're looking at what kind of conduct is affecting affecting our consumers, and if there's a violation, we act. And I think to this point about, yes, the heightened use of algorithms is just creating more, not new questions of whether or not we focus on a particular industry. It's more, hey, is this thing that's happening with this particular new kind of tool, or this tool that's accelerating in its use, is it being done in a unilateral way, or is it being done in a coordinated way? That's essentially the key question, I think, that's driving a lot of these matters.
So Adam's completely, I think, correct on the role of the states here, and Teddy, you were talking about, at least initially, I think housing is an area where those basic pocketbook issues are important. In terms of outside counsel, as I think about at least my practice and what we're trying to do, we really do view ourselves as trying to put ourselves at the service of states. So from, it's really, how can we help state AGs accomplish what they want to accomplish? And one area where a state might see that advantage is particularly where there's a high risk on the legal theory. The states can take advantage of, say, a contingency arrangement where the law firm is taking, you're shifting that risk, which is a way to actually expand your capacity. So I think particularly in any groundbreaking area like algorithmic pricing, a state might be able to pursue that using outside counsel where they may not have the resources or the risk tolerance based on their budget to do it without shifting some of the risk. And then as to Adam's talking about on the parents' authority, I think this is really important and maybe underappreciated is, look, the courts have really made class certification difficult, and companies have passed, require arbitration everywhere or significantly. All that means as the result of making it really difficult for individual consumers or businesses or workers to recover damages that Congress has thought they should have. states have the authority to push all that aside and come in as the parents patriae authority, saying there's an antitrust harm here and we can recover and may be able to do it more efficiently than where in some cases than private enforcers could, because of both court decisions on class certification and the use of arbitration clauses.
Yeah, let me just one coda to everything Mike just said, which I agree with, which is that because of exactly the features that Michael's describing, it shouldn't really surprise anyone that both blue and red states are, depending on what their particular statutory schemes allow, increasing their at least consideration, if not use, of outside counsel. And I think there's an easy critique of that says, well, wait a second, you're just enriching a bunch of plaintiffs' lawyers. Why are you doing that? And there's actually, I think, a pretty compelling response, which is that oftentimes when we are doing it is precisely because they are some of the types of cases where class certification may be harder, where arbitration clauses may block consumers, where essentially it may be the states that do something, or there's nothing. So what would you rather? Would you rather have the state bring litigation that it otherwise might lack the personnel, not to mention the budget for experts, or perhaps have to give a percentage of what is recovered to the outside counsel, which I will flag is generally lower than the percentages that they ask courts for if they're filing class cases? Or would you rather consumers recover nothing after being overcharged pursuant to anti-competitive conduct? And would you rather forego any chance to get meaningful injunctive relief, which the states will also always push hard for, whether it's outside counsel litigating it or whether we're the ones litigating it?
Yeah, I mean, it's analogous to the False Claims Act, right? Like, it's like, you're recovering money for the government, for the people, and it's just another way of making sure that enforcement gets done. I don't find that really controversial. I could see people who don't like lawyers or what have you having an issue with that. There's a related question here from the audience. We got two questions from the audience. If you guys don't mind, maybe we'll just race through these. One is, how we've talked a lot about the different potential values from some states and what's going on with the federal government, enforcement priorities, things like that. How has that affected coordination between government agencies and the federal government and the states when it comes to working on a merger or a Section 2 case together? Has there been any lack of coordination or any skepticism or what have you that you can talk about? I don't know what Adam could say, but Michael, any thoughts there?
Well, so I don't know what I can say, given that I'm not there. When I was at the Justice Department under Jonathan Cantor, it was really important for us to work with the states, not as a sort of virtue signaling. We really felt we viewed both the states and private enforcers like we were all different ways to achieve the same results. And frankly, one of the things that made that easy was antitrust wasn't a partisan issue, right? It was, you had red states that were concerned about enforcement and about the lack of Section 2 enforcement. You had blue states. And that makes it a lot easier to work together. The question is, in this environment, has that consensus begun to break down? And I'm not there, so I'm not going to comment on that. But I can say that I felt, from my perspective, it was really easy to work with the states, and it was really beneficial to enforcement. We talked about the NCAA case, but the airline cases, the AgriStats case. There's just a number of cases where it was, we were able to I think improve our enforcement. But it started with the fact that it was not ideological, or it was not partisan. We kind of all had a view of what the problem was.
I'll just say I'm gonna, keep my remarks
You
kind
don't
of high
have the
level
answer.
here, but
You don't have the answer, but yeah,
let
whatever.
me give you 3 points, because I think this is actually relevant. Like, one is, I think it's important to remember that most of antitrust enforcement happens at the line staff level. Okay, functionally, the coordination, the cooperation, the working together, the figuring out who's staffing which depositions, which parts are we going to investigate further. This stuff is happening between career lawyers at the federal government and in the state government, and that continues no matter who is ultimately, pulling the strings at the very top. The second thing is, it's still early days. The new administration didn't really have people fully installed for until the last few months. And I would say currently, just saying objective fact, I have not noticed a material change in federal enforcers. I don't know what your sort of questioner is thinking here, Teddy, but if the notion is that they're somehow being less forthcoming or less solicitous of wanting state participation in matters that they think are going to affect the states, no, I haven't seen a change in that at DOJ or FTC.
No, I think that's really interesting. Just given the turmoil at the top and the HPE thing. Let's keep going. Last question here. Coordination between state AG offices and private plaintiffs. It's not really a question. It just says those words. I imagine, coordination or intervening, and AGs working on with big private cases. What's that like right now? How do you think about that?
I think it's complicated because I think we all generally share a common interest, both in the sort of layman sense and generally speaking in the legal sense too, in the sense that we should be able to cooperate and have asserted that. But also sometimes class plaintiffs are ostensibly, depending on how you view the case law, are going after the essentially the same pot of money, to be kind of crude about it, as state AGs that might be proceeding in a parent's capacity. I think there are always going to be situations that have to be evaluated sort of case by case, which one is stronger. There's a serious policy consideration that state AGs are going to have to take into account in deciding whether to proceed in a parent's capacity, which is the class case got a better shot at obtaining relief for residents than a government parent's case is, because if we feel strongly enough that we can that people will get the right injunctive and monetary relief without our participation, we don't need to have we don't have a profit motive. We don't need to do that kind of work if we are confident that others are going to get our residents the kind of recovery and the kind of injunctive relief that they ought to. And if people disagree, then we do our best to figure things out. Traditionally, a lot of the time, states have tried to essentially get carved out of class cases where states brought parents' actions. It's a delicate art, but people are doing it in multiple cases, and we generally have the same underlying goals in mind.
Michael, any thoughts?
I would just add, it's the nature of the beast. You have federal enforcers, state enforcers, private enforcers. They all have overlapping but distinct interests, and you have to, the first step is recognizing that, and realizing when people have they represent slightly different interests. You have to work through those, and at least I think the best way to start is people aren't acting in bad faith until you have evidence otherwise, and a lot of it.
Not only that, but you also have to remember that a lot of these folks are going to be repeat players, right? Someone who is class counsel in one case might be representing a state in an outside counsel capacity in the next. So be careful what kind of arguments you make, because you might be, shooting yourself in the foot later down the line.
Well, Adam, Michael, this has been amazing, fascinating time, fascinating conversation. You tackled a very, very tough topic, the future of antitrust enforcement, extremely well. I can't thank you enough for taking the time today.
Teddy, it's always a pleasure. Thank you so much for having me.
Really appreciate you having us on, Teddy. Thanks a lot. Thank you, Michael.
Thanks, Adam. Thanks,
Adam.
Michael. And to everyone else on the call, this concludes the call. If you found the conversation helpful or thought-provoking, be sure to follow Capital Forum on LinkedIn, X, or Blue Sky for breaking news, policy updates, and information on upcoming events. We'd love to hear from you. Drop us a line at events@tcfpress.com. If you have ideas for future topics, speakers, or just want to connect, happy to hear from you. Have a great day, everyone. And thanks again, Adam and Michael. Bye-bye.
Bye.